and you have received the counseling, call for counseling process. But as you've been appointed in a case of the 2019, 2016 process, then my lord, we could not participate in the counseling process. Although we are the higher marks, we are the impaneled candidates. These are the unfortunate part on our because of the fact that the citizens are working at that point of time. We have no idea about the fate pending before the division bench, pending before the Supreme Court. We my lord could not participate.
But counseling process is nothing for choice of schools.
Yes.
Yes. Now, if a candidate who did not participate in the interview, how he can get? You come to your peer A.
Yes.
To allow the petitioner to take part
Yes.
as well as the interview process. That means you have not appeared in interview.
That is the separate process. First the written test, thereafter the selection, thereafter the oral interview is being conducted. So far, my lord, first, second pass, we have successful. In the counseling process or interview process, whatever we are calling, my lord, we could not participate because of the fact we were discharging our duty. As my lord, our case is pending before the.
So if your prayer is accepted by the court and court finds that your prayer is or your contention is justified, then they are to ask that you conduct an inquiry in interview process and allow him to participate that interview process. Thereafter, you allow him to participate in the counseling process.
Not the interview process, there is a counseling. Document verification is other things. We have been selected.
No, personality test. Interview means we know personality test.
The counseling process. Maybe there is a wording mistake. It is a counseling.
Kindly see paragraph 8, what my learned friend. Paragraph 8.
Now
the same statement is there. They want verification and to appear in a personality test which was held in 2021.
Yes. Service Commission for
interview.
The testimony.
Let the regular bench hear it.
As well as the interview for the post of
move it before regular bench. That would be important. Move it before.
Similar candidates, they have not been allowed.
Your lord, the circuit bench. Circuit bench available up to 2 weeks after the vacation, not 3 weeks. 3 weeks the next circuit bench. Some problem we will have.
No.
If it is 2 weeks, well, we can move there.
Okay, it will be able to. Yes.
May I file
What is the matter?
item number 1, Delhi list today.
তাহলে এটা কোনটা ছিল? ও জলপাইগুড়ি।
May I file the affidavit of service? My lord, this is my lord surfacey matter, my lord. I will show your lordship against 13-4, my lord. They approach before DRT. Subsequently, they approach before DRAT. All occasions, my lord, they failed. They approach before this court asking for it. My lord, let me submit. I will show your lordship. My lord, possession has already been taken. What is this, my lord? This is my case, my lord. I have not been allowed to, my lord, make submission. I have not been allowed to make my submission. My lord, I have got the Supreme Court decision. My lord, this honorable court has decision. I have got that decision. Well, what is this, my lord? This is my petition, my lord. There, my lord.
Okay. If everyone started shouting whether it is possible for a particular person to understand.
My lord, respondents are, my lord, not allowing me to, my lord, make submission. But this is, my lord, we are approaching this honorable court, my lord. Let, my lord, why, how, my lord, I put this question.
Okay, one by one.
Well, I put this question, how the respondent can, my lord, first make submission. They will get that done. They will get that done. I have got the decision of the Honorable Supreme Court that this court has got jurisdiction to entertain this petition. My lord, I have challenged the propriety of the order passed by the learned CGM in, my lord, exercising, my lord, jurisdiction under section 14 of the Surface Act. My lord, I have approached the, my lord, appropriate authority. Well, it is not that, my lord, I have not touched the, my lord, efficacious remedy. My lord,
possession has been taken.
My lord,
they
moved before DRT. DRT they didn't allow. Against of which they prefer in appeal in DRAT. And then, my lord, they approach before your lordship, challenging, my lord, the order passed by CGM. My lord, this court does not have any jurisdiction to entertain any such application.
Yes,
My
my
lord,
lord,
law
I have-
said so.
Yes,
My lord, I'm not relying any.
Well, I also
Any
cite
judgment.
judgment, my lord. I will also
Lordship
cite
kindly
judgment of
see-
Honorable Supreme Court.
Your
Lordship,
lordship
kindly
kindly
have
see
a
page
look, my lord.
paragraph 3.
Paragraph 19, my lord. Kindly have a look.
Come later on, my lord. Your lordship see the law first.
My lord,
Your lordship kindly sees the law.
law is, my
There
lord,
is any scope to interfere order passed by CGM 3, 14 subsection 3. এটা বার কর। বার কর এটা। Your lordship see, my lord, section 14, subsection 3. And my lord, on previous occasions, your lordship dismissed various writs on that ground.
my lord, kindly have a look to the judgment, paragraph 19. My lord, the jurisdiction of this honorable court is plenary. My lord, Honorable Supreme Court, hell, even the statute does not provide. My lord, still this honorable court has got jurisdiction to entertain.
How, my lord?
226. This is the decision of the Honorable Supreme Court.
Well, how similar prayer they
you
move
are
before
challenging the order of
DRT.
the Honorable
Your
Supreme
lordship
Court.
see the prayer of the
You are
DRT.
challenging the order of the Honorable Supreme Court. My lord, kindly have a look, paragraph
My lord,
19.
compare the prayer
My
of
lord, kindly
DRT.
have a look, paragraph 19 of that judgment, my lord, reported in 2012, volume 11, Supreme Court
And my lord,
cases.
further one read also
What
filed.
is this? I
Item
have
number
not been
40.
able to submit. What is this, my lord? We are arguing before your lordship, my lord. I am not being allowed. They will get their turn. আমাকে বলতে দেবে নাকি আশ্চর্য কথা।
আপনি একসঙ্গে দুটো রিট ফাইল করেছেন সিমিলার
This is my lord will decide.
কোর্টের টাইমটা তো নষ্ট
Not quoted the said that my lord will decide.
Which judgment? Yes.
My lord, kindly have a look, paragraph 17, my lord, of that judgment. May I read for your lordship, my lord?
Mhm.
Considering the settled position of law that the powers of this court under Article 136 of the Constitution and the powers of the High Court under Article 226 and 227 of the Constitution could not be affected by the provisions made in a statute by the legislature, making the decision of the tribunal final or conclusive. This is my court, my lord.
Okay.
My lord,
Now allow the court to pass the order.
my lord.
তলায় লিখে দেবেন 13 within bracket 4-24. Next.
না না ওটা নয় আইটেম
Wait, please, brother.
আইটেম টুটা রাখলাম কোথায় গেল
আচ্ছা ইয়ে
এটা
আপনার রেগুলার মিস্টার ব্যানার্জি is there.
Your lordship kindly dear, because since they have been engaged before you by your lordship's order, your lordship kindly record that so that
আচ্ছা so ওটা ইয়ে করে I find আচ্ছা ইয়ে
if no one appears, not kindly not regularize their appeal.
if anyone appears and say that I was assigned the brief, it was assigned to me, anyone from the state.
Then I am here, Lord, I will assist your lordship.
Yes.
I'll take the responsibility on my shoulder.
আচ্ছা so 40টা লিখে দেবেন আচ্ছা non appears
For item 2, Lord, I appear for the state.
This is a proceeding under West Bengal Public Unauthorized Occupants Act 1962. My lord, may I rush in vacation mode, my lord? 3 points, my lord. First, my lord, common order, common proceedings and common order has been passed under the 62 Act as well as 64 Act, which in my humble submission is not permissible in law. Under West Bengal Public Unauthorized Occupants Act 1962 as well as West Bengal Highways Act.
there is an appeal, you prefer appeal.
My lord, appeal has been preferred. Again, in the appeal, we had raised this point.
So
The appellate court ignored. Despite directions of this honorable court, before going to the appellate court, we had come before my lords.
they initiated proceedings under 62 Act.
2 proceedings.
62 Act,
Under
collector,
Under-
collector, your collector is the fact finding authority and the commissioner of division is the appellate authority. So what do you say? What is your submission?
Without availing the appeal.
SDO cannot.
SDO has invoked both the provisions, which he cannot. Again, we preferred an appeal before the authorities. There we raised this point, but the appellate authorities also ignored this point and passed an appellate order. against us.
Huh.
May I
This
say?
is our first point.
So move it before the regular bench, no such urgency, okay?
There is urgency. There are two other points, Malad.
Admittedly, it is a public land.
No,
Public
it is not. It is not.
So there is a dispute regarding title.
বলতে দাও না।
Yes.
So the civil court is the appropriate forum. Go to civil forum.
Settle of the matter at the behest of the private respondents. Appeal is pending.
And may I say one thing? May I say one thing?
Malad, these orders have been passed against the dead person. Malad,
First-
the post title of this is
First of all, my lord,
Radha Gobindo Das and
This-
others versus
this
State of
writ-
West Bengal. Radha Gobindo Das is no more. At the time of passing of order by the SDO, he was already dead.
let this,
So this is an order against a dead person, which is nullity in the eye of law.
let, may I say one thing? But first of all, my lord, the writ petition, whether it's maintainable or not, your lordship kindly decide. Only that if your lordship kindly see, so many orders have annexed in the writ petition from 2018, one after another writ petition moved and order was passed. But every order, my lord, it was established as a land is a public land. However, my lord, last, my lord, Justice Aniruddha Rai, my lord, was pleased to give them liberty to approach before the district magistrate.
No, approach করেছি তো ওরা
Oh, आप बोलते तो भाई আমি বলেছি কি district magistrate. Well, accordingly they have approached. But district magistrate has made these findings. Just now your lordship fell from your lordship's mouth. There is a statutory appeal before the commissioner. Without availing that, how the writ jurisdiction he will invoke? Lordship kindly consider
They
that.
are saying that they prepared the appeal. Where is the so the appeal?
No,
So the appeal you have prepared.
Order page 171.
no, appeal. My lord is asking for appeal. Yes,
No.
no,
Because there is procedural impropriety. here.
yes, my lord, they have not.
This is
They have not.
an order passed against a dead person.
But kindly, my lord,
Ah, so
dispose it of-
yeah. Okay, so SDO passed the order, then the appeal lies before the commissioner of division. File that appeal. Oh,
My lord has given me that liberty. Malad.
and will not preclude.
Well, the next,
in the provision, the liberty is there.
my
But
lord,
what liberty is required not
My
from
lord,
your lordship?
the next matter who is identical here. same
I am to go on shouting out up to five. Okay.
এটা নাও।
Yes, next.
It's identical.
Next matter,
Identical,
but
same
order 64.
Identical, same order,
order.
next.
64 Act, my lord.
Huh?
Let it be relegated to the regular bench. This is 64 Act.
No. No, lordship, similar.
Similar, but
Similar.
64 Act.
No, 64 Act. Justice Aniruddha.
62 Act?
No. This is 64 Act.
Blood,
Item
Okay, forget it is highway land or public land?
public land.
Huh?
Highway land.
highway,
Highway land.
64 Act.
But blood, the.
Okay. Which
they have
order
already
you
passed
have,
the order.
which order you have challenged? Towards the order?
175. 176.
It is 10-4.
Identical orders. my lord.
Okay, yeah. Identical, okay, it will regular bench.
Regular
Regular.
big lot.
64 Act.
No, there is a provision for appeal. You can.
Appeal paper.
No.
The 10-4 appeal paper.
কোথায় paper?
হ্যাঁ।
কোথায়?
ওই যে 174.
কোথায় state appeal?
174.
কোথায় DM এর কাছে করেছো তোমরা নিজেরা?
Yes, their DM is the appellate authority.
DM already passed the order. Yes.
They have challenged that order.
They have challenged that order.
Regular bench,
10-4.
Regular.
10-4.
regular bench. Next.
41. Your lordship,
Next.
it's 41. 41 top. Your lordship see 3 top, then your lordship asks me to. Yes.
Wait. Put to the,
41.
wait. No, need. At 14 need. Next.
জানি না।
Item 4. Yes, my lord, I am for the petition.
কি বলছে দেখি ভাই দাঁড়াও।
My lord, we have served the copy to the state through mail service as well as the,
You are asking police help to allow him to construct a boundary land.
yes, kindly appreciate me, kindly I submit.
Whether it has been served upon this government peter's office or not, I do not. It has been served upon the government peter's office or not, I do not know, my lord.
Kindly sees we served the copy through mail service and subsequently on earlier occasion when the matter was placed before the Honorable Justice Ghosh, we served the copy.
No, where you have served upon the government pleader, you so?
Kindly seize the mail service, kindly seize the.
Mail service.
What main service? You show that government pleader, office of the government pleader has received
It will be
the
moved in
copy of the
petition page.
petition.
Please, please.
So,
You see, this is the mail service. And when the matter was pending before the Honorable Justice Ghosh, we served directly, kindly seize the another service to the government leader. Just, you see,
it is an intimation.
definitely, because the problem is right now, so the question of service is very difficult to the government office. Because of the fact, my clerk went to that office to serve the copy. They have said that today is not, we are not.
Okay, he is trying to restrain the private respondent.
Private one is here.
Because-
Private respondent so that he cannot prevent him from making boundary wall.
Yes, because there is a.
And there is no need to civil court.
Even there is a.
Why civil court are
Come to
so much money will be invested
Yeah,
from
allow-
public exchequer?
Kindly allow me to submit.
Yes.
There is a very strong primacy case of the petitioner
Hmm.
because there is a ad interim injunction order passed by the civil judge in favor of the petitioner. Kindly, we have annexed here with.
Hmm.
Even the 144 is also there.
Hmm.
Apart from this, there the petitioner is the owner of the property. So I may kindly be allowed to only to protect me in this way because we made a representation with the annexed copy of the civil court and as well as the 144. But the police is not.
Where
taking
is the
any action.
civil court order?
Kindly come to
Page
29. Page 29.
Page 29,
Yes.
okay. What order civil court has passed?
Kindly come to page 29.
What order?
Kindly see page 29.
29 is the no, 29 is the first page of 135 copy.
Start from 29, then 30 and 31. 31 is the ordering portion.
Are restrained from private dependent and their main agent are restrained from disturbing peaceful person of the plaintiff.
Yes, I am the
That
plaintiff.
means peaceful person means making boundary wall.
No. Kindly come to.
Huh?
No. Kindly come to. I am the owner of the property. I am in possession over the property.
One civil suit is pending, whether you are owner or whether
My lord, so far the article 300 is in concern of the
Article
Constitution.
308.
300A of the Constitution of India.
Huh.
So I may kindly be allowed to protect my property
Hmm.
because it seems to be believed from the series of order,
Hmm.
even the executive order and the order of the learned civil judge.
So
That
during
we are-
pendency of the civil court, writ court will pass and allow him to
No.
construct the boundary wall.
Because in a similar situation,
There's one another civil suit from
But-
our side also pending. There is a status quo order.
that is the subsequent order. We have passed the order earlier. Kindly
In the
seize
same
this
property,
in
Your
similar situation. Kindly seize. In a similar situation, kindly
So
seize.
there is boundary regarding the boundary.
Kindly
Huh?
seize.
There is no boundary, Your Honor. There is a dispute between the parties regarding the same land. We have
My lord,
also
kindly
posting one
seize-
order, Your Honor.
My lord, kindly seize in a similar situation.
Actually, the present petition has been in
Addressed
terms
to
of the
me.
engagement letter.
wherein the lease which was granted to me to run the ferry ghat, now that has been cancelled unilaterally without giving me any opportunity of hearing. My lord, this particular notice kindly come to clause 4 of the notice dated 14th May 2025, annexed in page 33, annexure P6. Clause 4 says, আগামী 24/5/2025 তারিখের পর নতুন ব্যক্তিকে ফেরিঘাট হস্তান্তর করা হবে। ক্লজ 3 সেজ নতুন করে গায়েনপাড়া ফেরিঘাট লিজ না দেওয়া পর্যন্ত আগামী 23/5/2025 তারিখ পর্যন্ত আপনি নিজ দায়িত্বে ফেরিঘাট চালাবেন। নাও লিজটি বাতিল করা হলো ক্লজ 1 গ্রাম পঞ্চায়েতের চুক্তিপত্র অনুযায়ী কাজ না করার কারণে আপনি চুক্তি ভঙ্গ করিয়াছেন। চুক্তিপত্রের ভাড়ার তালিকার থেকে আপনি দীর্ঘদিন অতিরিক্ত ভাড়া নিয়েছেন। Now lordship kindly straight away then come to the original agreement which has been referred there. Now that is in page 26 that was granted in 10/2/2025. Kindly come to P3 page 26, 10th February 2025 issued by the same Pradhan, which says, my lord kindly come to, it was addressed to me Niranjan Gayen. এতর দ্বারা জানানো যাইতেছে যে 27/11/2024 তারিখে ভাটোরা গ্রাম পঞ্চায়েত অর্থ ও পরিকল্পনা উপসমিতির সভায় সিদ্ধান্ত গ্রহণ করা হয় যে গায়েনপাড়া ফেরিঘাট 1 বছরের জন্য লিজ দেওয়া হইবে। গত 25/1/2025 তারিখে গায়েনপাড়া ফেরিঘাট ডাক হয় এবং নিরঞ্জন গায়েন 20,10,1,000 টাকা সর্বোচ্চ দরপত্র দান করিয়াছেন এবং 27/1/2025 তারিখে 2,01,000 টাকা মাত্র ভাটোরা গ্রাম পঞ্চায়েত অফিসে জমা করিয়াছেন। নাও লর্ডশিপ কাইন্ডলি কাম, অর্থ পরিকল্পনা উপসমিতির 10 ফেব্রুয়ারি 2025 তারিখের সিদ্ধান্ত অনুযায়ী আপনাকে 27/1/2025 থেকে 26/1/2026 তারিখ পর্যন্ত গায়েনপাড়া ফেরিঘাটে লিজ দেওয়া হয়েছে। সো আই এম উইদিন দি লিজ পিরিয়ড মাই লর্ড। So within the lease period, my lease has been cancelled unilaterally by the Pradhan without giving me an opportunity of hearing and as giving an aspersion against me that I am charging more fare as decided by the panchayats. Now, Lordship, kindly come to what is the fare rate provided. Ferry parapare rate chart. প্রতিজন 2 টাকা, মোটরসাইকেল 5 টাকা, টোটো 10 টাকা, ইঞ্জিন ভ্যান 15 টাকা, 3 চাকার গাড়ি 20 টাকা, 4 চাকার গাড়ি 25 টাকা। Now, Lordship, I have taken the rate chart which is displayed in the ferry ghat, which is, Lordship, kindly come to page 28. This is still there, and if today also my lord sends any special officer, this is the ferry rate chart which is there. Here, Lordship will find that জন পিছু 2 টাকা, bike 5 টাকা, cycle 3 টাকা, toto 10 টাকা, such and such, it is still there. So, my lord, kindly protect me. Otherwise, this is within the lease period, and without assigning any reason, this lease cannot be cancelled. This is my humble submission.
Alam, I am for the Pradhan. Can you see? What is the complaint?
You are for the?
Pradhan, my lord. Can you see what is the complaint against the my lord petitioner?
What is the name of the petitioner? Niranjan?
Niranjan Gai.
Guy.
Can you see the mass complaint, my lord? Mass petition, my lord. Several time, my lord, after receiving the complaint by the panchayat authority, my lord, several time, my lord, the panchayat, my lord, issued a notice to the my lord petitioner, my lord. On my lord, April 30, 2025, my lord, the panchayat issued a notice upon the my lord petitioner to appear before the panchayat authority relating to discuss about the complaint, my lord. My lord, after that, he will not appear, my lord. After that, my lord, can you see on
No, whether you have given him any opportunity of hearing before cancellation.
but, my lord,
There is no provision for cancellation in your document.
my lord, before cancelling, several notices have been sent before the.
Where is that?
Can you see? Can you see the notice dated, my lord, 13 May 2025? 13 May, my lord, notice.
It is my lord.
It is my lord. Before cancelling, my lord, notice has been sent. Can you see? The signature of the petitioner is there.
I do not know what is being shown to your lordship.
Can you see, my lord? The petitioner intention.
Notice was served, Mr. Chatterjee.
Lordship, kindly come to. No, page 33.
Kindly look this. Look at it.
Lordship, kindly.
Notice was served, and people of the locality make an
Lordship,
allegation
kindly
that
come to one thing. Kindly
You are
compare
realizing-
this notice.
Instead of, my lord,
No, compare this notice with page 33 once.
page 33.
Yes. This is the notice dated 13/5/2025. আপনাকে জানানো যাইছে গত 30/4/2025 তারিখে অর্থ পরিকল্পনা উপসমিতি।
Okay, I have read it. It is 14th May. It is 14th May, but that notice
This is 13th May.
13th May.
13th May. Decision is on 14th May.
So you didn't appear. You refused to
The
accept.
question is the Oddo Taro. This was issued on 13th.
panchayat authority, my lord.
This was issued on 13th, and decision is taken on 14th.
Before 30.
There was no question.
Notice has been sent.
This is on 13th.
also.
Kindly see, Lordship.
Before 30.
13th it was issued. It says that Oddo 13/5/2025 অর্থ পরিকল্পনা উপসমিতির সিদ্ধান্ত।
Okay, you give an opportunity of hearing.
Yes.
Huh? Till that it would be stayed.
Yes.
Huh? Okay. Acha, the patient.
May I file my affidavit of service? Lord, I'm. Yes, senior.
Case mark in examination under reference.
Examination, my lord. Your lordship would kindly consider that the petitioner before your lordship is an.
He is expected to be declared on 14th May. Okay, regular bench.
Your
ninth
lordship
bench.
would kindly, my lord,
Regular
consider,
bench, ninth
your
bench.
lordship would kindly consider one aspect of the matter, my lord.
9 June,
My lord-
regular bench, 9 June. Regular bench, 9 June, 9 June.
Lord,
Next,
there is
next,
some
next.
urgency, my lord.
Oh, okay. No, sir, no. Next. 9 June, 9 June. Next. ডেকে দেবেন আপনি বুঝলেন ম্যাডাম আমি ঝট করে ডেকে দেবো।
My lord, in this matter, state has not met party, my lord.
আচ্ছা ঠিক আছে আপনি 7টা থেকে দিন কোনটা সাপ্লিমেন্টারি কোনটা এটা একটু পরে নিচ্ছি আপনি 7টা দুটোর সময় নিই নাকি সব বসে আছি নেক্সট
seven.
সাপ্লিমেন্টারি স্লিপ ডাকলে দাঁড়ান হ্যাঁ এটা 12টার সময় বলেছি কে বললো আমি বলেছিলাম
Yes, my lords. At morning, we have taken leave from your lordship.
হ্যাঁ
In the morning, we have taken leave from your lordship.
this is the case দুটোই বলতে দিতে পারে
The chief justice himself has granted leave.
হ্যাঁ The presence of state is required. Who is for the state?
That we have served them, my lord. Advance notice has been given. It was 2 days back.
No, in this way, yeah, আপনি এটা ইয়ে করে
My lord, is it the case of that Panoli, madam?
They are appearing, my lords.
Ah, yes, you are for the state.
Yes, I am
appearing for the state, my lord.
Yes, my lord, just 15-20 minutes back it has been served and we have
Ah, yes.
very difficult, my lord, to argue a case without getting myself ready to argue the case is very difficult. And instead, my lord, let him hear, but he was already arrested, he was produced. The court has rejected the bail and the matter has been on 13th June matter has been fixed by the competent criminal court.
My lord, it is our petition. Let us at least start. My friend is taking an
No,
objection.
Mr. Banerjee is claiming that you only 15 minutes ago you have served the.
No. That is not correct.
You have taken the leave at 11 o'clock. How
It
can
is
it
there.
be?
It is
Well,
there.
he had taken the leave at 11 o'clock.
No. Leave was granted by the honorable.
No, Honorable Chief Justice have granted them leave to move the vacation bench today. I have been told.
Yes.
All right, Miller, let them move. I will make my submissions. But kindly consider that we are not appropriately
Today it
ready.
has been served. Today.
This is not done. When it has been served, not everything.
correct. I'm in
You are
charge
only
of your-
correct. Not correct. You are only correct.
Okay, Mr.
What is
I'm in
this?
charge of the
Sir,
office.
I am making the
I'm
submission.
led by
He is
Mr.
not
Bandyopadhyay
correct.
in this matter.
You are-
I'm in
are you
charge of the
are you
office.
coming from
Today,
the
my lord,
heaven?
after coming to the court, I came to learn that this matter has been moved today and leave has been taken from your lordship.
My lord, I don't.
No. Leave has been
No,
taken
that's
by
right. I've heard. But so far as
from
the
the Honorable the Chief Justice. Honorable the Chief Justice, it has been mentioned in the year that leave
Morning,
has.
that's all right. My lordship, can you proceed with the matter? I will make my submission.
Mr. Banerjee is saying, asking the court to
Proceed.
proceed.
We will make the submission, but by my lord,
led
all
by
the
Mr.
case laws are
Bandyopadhyay,
not with me.
whatever
I
you
will tell.
Okay, what's the matter?
Yeah, please, my lords.
Acha, what's the problem?
My lord,
Why you are so
allegedly, on 7th of May,
Yes.
as a student, when the Operation Sindoor started between India and Pakistan, there was on social media a war of words, allegedly by various people, my lords, across the border. In one of the rants, it is alleged that while replying that we are delusional, there is no proof why we are fighting Pakistan, why we are blaming Pakistan. So this girl allegedly had a post in reply to that, where it is alleged that she has said something beyond replying that we are not children of Mahatma and all. She is alleged to have said that you must be delusional. Your Nabi must be delusional when you are talking. Delusional. My lord, there is nothing otherwise alleged. Please see the FIR and we'll start by the, my lords, how they go about it, my lords. Please see the FIR
And that FIR is on page, my lords, 18, 18. Does it disclose an offense? That is the issue, my lords. My lord, the complaint is on page 19, and I'll read it. Two officers in charge, Garden Reach Police Station. Subject, demand to register FIR against one resident of Kolkata named Sharmishta Panoli under appropriate section for hurting religious sentiments of Muslim community around the country by insulting Holy Prophet of Islam in a very abusive manner. Respected sir, this letter is to draw your attention that one lady named Sharmishta Panoli, resident of Kolkata, likely from Urbana NRI Complex, Kolkata, and pursuing law from Symbiosis School of Law, Pune, has made blasphemous comment on the Prophet of Islam in a very abusive manner. This kind of act brings disharmony, unjust, unrest in the society, and as a resident of Kolkata city, we will not tolerate such kind of blasphemy against our Prophet in our city. We demand to register FIR, action against her under appropriate section for hurting religious sentiments of Muslim community around the country by publishing blasphemous content against the Prophet of Islam on X, formerly Twitter, and on Instagram, which is being viral on social media around 4 p.m. 14/5/2025. We are attaching the link for the video in which one lady, Sharmishta Panoli, has blasphemically commented on Prophet of Islam with a dirty mouth in which she abuses the Holy Prophet and try to bring disharmony, unrest, and communal dispute around the country. Thus, we demand strict action against such hate monger as soon as possible from Kolkata police to maintain peace and harmony in our city, around the country. Such kind of blasphemy are completely intolerable by Muslims, and we will not rest until strict action is being taken against such hate monger. Hope Kolkata police will do their best to bring justice and maintain peace. My lord, I ask a question to myself. Where is that content which says, they are saying, I made blasphemous comments? What is that? Today, as we read this, it does not disclose a cognizable offense which they have registered. Now, please see, this is registered on 15/5, and that is important. 15th of May, this FIR has been registered. On 17th of May, they take warrants of arrest against me, my lords. Warrants of arrest has been taken, my lords, saying that I am not available in my house, and because this is punishable with 3 years at best. So they say they can't arrest. They have to give notice
35B.
under 35B, erstwhile 41A. But instead of that, they say we went there and they were not there. They're absconding, their phones are switched off, and therefore obtains a warrant of arrest. Now, my lord, there are two things. Parallelly, on 15th, I am before the police station with my complaint saying that I am under acute threat. I am also seeking an apology for whatever was sent. That post was taken off on the 8th May itself, after making it on 7th night. The question today is, my lords, twofold. The law gives me protection, and that protection is, first, you have to register a case only if it, my lords, the contents of the complaint, my lords, show commission of a cognizable offense. This FIR does not have any content. So now I am left with something called a video, a link. My lord, that is why a provision of inquiry is there. First of all, you have to see the link as it is. If it provides that there is, then you will, my lord, ask whether it is. Two questions will be asked. Is it tempered? Is it original? And how it is? Nothing has been done. And warrant of arrest has been obtained. On 15th, 16th, 17th, there is a crowd in front of my house. There is a threat, and I've attached, my lords, right from sexually explicit, my lords, photographs of my daughter, this girl. Also, my lords, the threat of beheading her, the threats of rape, all they were there. My house was found to be, my lords, attached with this thing that I live here. I study in such and such place. This is my father. My father's photograph is also there. So, my lords, we go to the police station on 15th, 16th, 17th, all 3 days. We are asking for protection and security. And my lords, when it is not given till 19th, we are every day going to the police station. My father is going to the police station every day. And on 19th, when there was a crowd in front of my house at 10 o'clock in the night, my lords, that is the time, my lords, the family decides that now a crowd is assembling, the threat perception is increasing now because it has reached the doorstep. My lords, my father takes the family to Delhi, my lords, Gurugram, the Gurgaon, my lords, earlier. And they are there for some time till the time the threat perception is answered. My lord, because threat perception is continuing. So the phones were switched off because dirty messages, threats are time and again coming. There was a scare. So the question is, my lords, please see what needs to be done at that time. They have to show to the court while taking arrest why I was not there. My phones were available on 17th. It could be ascertained. I am there in my house. It can be ascertained. I left this place on 20th. The warrant of arrest was obtained on this. So, my lord, we'll have to see two things. Whether the registration of the case was proper, number one. Whether my warrant of arrest was taken as per law, disclosing, my lords, facts otherwise which are right. What is the offense against me? Am I a terrorist? Why are they witch hunting? They go all over the country, my lord. They raid everywhere. I did not know. Now I'm coming to know that they have been raiding after this. Whereas I'm here till 20th. So they go, my lord, arrest me by using that technical surveillance. They can do that everywhere. But not one action has been taken on my complaints, on security, on my threat perception, on those, my lord, grave threats which are offense beyond 7 years. Then, my lord, the complainant, I will show that, my lord. I'm giving a summary.
We are in a hearing stage or motion stage in some other cases. I don't understand.
Now, what do you want?
I want, my lord,
court?
on my three things, my lord.
Yes.
There should be, this should be quashed. My arrest should be declared in a writ petition as illegal, and I should be granted bail forthwith without any conditions, my lords. That is what
you are in custody for 2 days.
My lords, I'm in custody. Even if I'm in custody for 1 hour, the custody itself is illegal, and my lords will have to protect me. And that is
they have arrested in connection with a case.
Yes. My lord, but then case is about 3 years.
Arrested in connection with a case. Yes, arrest without in connection with a case is illegal.
Very well. And the registration.
You at best can say that they have not issued any notice under 35(3) yes, now. 35(b). 35(b) earlier 41(a).
Yes,
they have not issued any notice.
I have not received, my lords. What they do is, my lords, my lord, they obtain a warrant of arrest saying we served these notices, and it is only during the arguments we come to know.
Yeah, Mr. Banerjee, we will be able to produce the CD or anything.
I'm led by Mr. Bandyopadhyay in this matter.
Mr. Banerjee,
But CD is not available. Possibly, just let me tell me your lordship, the case is this. But this is a case.
If I can complete, or I can
under section 196. No. This continuing is not. It's not a hearing. This is not a case
no,
under
I'm
section
seeking my lord's permission.
Yes, my lord has asked me to. My lord has asked me. What is this? My lord has asked me. Don't show this posture.
No.
Mr.
Why
Counsel,
I saying
don't show this posture.
Court is to look into the materials which have been collected by the investigating authorities so far.
So as it
and on the basis of such,
my lord,
but the state is not in a position to produce the same.
So, my lord, I am seeking exactly that, and that is, I am before my lord. My lord is to grant me protection. The Supreme Court, in a number of cases, and I have brought the compilation. In all these similar circumstances, they say on the first date, even if state is not there, They say grant ad interim bail and then we can continue. I'm only seeking an interim bail. I can't be put into custody as a student, my lords. A girl student with all those, my lords, in that kind of circumstances, she is my lord, she has a ADHD problem.
She has?
Attention deficit, my lord. She gets impulsive. She gets, my lords. There's a problem. And staying in jail is creating a problem, my lords, for her. She has a kidney, my lord, disease she's carrying. All I'm trying to say is,
Yes, Mr.
I'm only seeking.
Madam, can I submit?
Yes. Yes.
I'm not running away.
Yes.
Can
Yes,
I submit?
Mr. Panoli.
My lord, kindly see, a case was initiated under section 196, subsection 1A.
Yes.
Then 299,
Yes.
352,
Yes.
353, 1C.
Yes.
Because of her ex-handle posting with a video. My lord, hurting the religious faith. Then, when this complaint has been lodged, my lord, it discloses a cognizable offense. FIR discloses itself is a cognizable offense. When this offense, my lord, it was done, notice was sought to be served under section 353 BNSS 2023 and 94 BNSS was notice served. Then section 94, she was called upon the steps were made for service. Then, my lord, with the assistance of the Anandapur police station case, and on both the 2 days, including 21st May 2025, however, the accused person or any of her family members could not be found there, and the flat was under lock and key, so the notice could not be served. Attempts were made. Then the, my lord, warrant was issued by the appropriate magistrate. My lord, they whole family, the lady fled away. She was arrested from the Gurugram. She was produced before the appropriate magistrate. Transit remand was given for 3 days. Then, my lord, she was produced before the magistrate. Bail petition was moved and was rejected
By the magistrate.
by the magistrate. Now, the, my lord, if they only ask for FIR setting aside, etc., that is a subject to hearing. We have to file affidavit. We have to tell this.
Now,
is not this.
whether there is no requirement, any requirement to keep this student in custody any further.
Yes, Milord, this has been, who will decide it? When once a matter is set in motion in the criminal court, how they can come into the writ court? They could have filed an application, bail application. How they can come into the writ court?
And how many cases has been registered against him? You are saying
I don't know
case.
exactly. We
I
have
am
to
saying Garden Ditch case.
This is in connection with the Garden Ditch.
He was arrested first case. Which was the first case?
Garden Reach, my lord.
Garden
Ditch was first case.
Yes, ma'am.
Madam, all the cases can be.
Cases has been registered.
Line by line, same, my lords. Word by word, same.
Madam, kindly hear.
My lord is
Yes,
asking the state. My learned senior will give answer. But if interruption is in such a way, then it is very impossible to.
Okay, do one thing. It is vacation bench.
Yes.
You produce the CD and Sadansa before the on 5th, before the next vacation bench, because of the fact material collected by the
My lord.
investigating
Yeah, at
authority
this initial
is to be-
stage.
is to be-
I am only on
today just. So I am just passing an order
My lord, please.
that this Garden Ditch case, PS case, shall be treated as a principal case,
My lord.
and the other case will
My lord,
not be investigated.
I
Exactly.
want to show something, my lords. My lords
Just
cannot
kindly hear me,
continue
my lord. Kindly
in this
hear
tension
me.
even for a day, and I will
My
show
lord,
that.
kindly hear me. My lord,
Not
kindly
even
just
for a
hear me.
day.
My lord, kindly,
That is
will
the
your
whole
lordship,
essence of law is.
will your lordships kindly
Cannot-
hear me, my lord.
Even for a day.
My learned senior,
Let me
Well,
show
I
you.
want
learned
to-
Why are
senior
you
is.
afraid?
Okay.
But if he's.
My lord, kindly hear me.
Mr. Banerjee, both Mr. Banerjee.
My
Well,
learned
kindly
senior.
just
Why arrest
Here
is illegal? Here, Learned Council, why arrest is illegal?
Yes, my lord.
They have not issued notice under section 35B.
My lords, please see.
But Mr. Banerjee has stated that such notice was issued.
Yes.
My lords, can I only
Dispute
say
a question of
something?
fact.
Yes.
Now, whatever inquiry will be done, will be done. 3 things are there, and that is undeniable. Today, the effort is that we will show only to delay something that is so sacrosanct to me, and that is liberty. It is only to delay my liberty. They are saying we will show, we will do this.
Day after tomorrow,
My
heaven
lord,
will not fall.
why even-
Only 2
My lord,
days.
this girl has suffered in these 2 days so badly. Please understand what she is going through. And I'm showing something, my lord. Please see.
She should have remembered when the external post was made.
Arrest me more.
Lower
This is
lower court order
He should have.
Is it in conformity
lower
with
court
the
order
law?
দেবো কল্যাণদা
Yes, yes.
Huh?
Give the
Or not?
give the
After
give the
this,
Lower court
not
order-
give
even
the
a-
magistrate's order. Please give the magistrate order. Suppose তুইও
order
চাচা না ও একা
That's not
চাচাবে
my lords, by the
It is
magistrate
warrant,
order.
warrant.
I am before my lords, and my lords,
তুইও চাচা ওকে একা
my lords
চাচাবে
will
নাকি
not be guided by a magistrate.
হ্যাঁ
my learned senior friend, but forget not the judicial discipline.
judicial discipline.
And they are not the judge.
I understand.
My lord is
Yes.
judge.
My friends don't understand the
We have understand. And you
judicial
want to,
conscience
you
itself.
want to, you want to
You are
give
coming from the moon.
by
That is the
jumping
reason
and
you are,
humping.
you are coming from the moon. That is the reason you understand more than anyone.
What is your good name, please?
I'm DP Singh, my lords.
So it would be better.
So, my lord.
I am asking, you will not, you will go.
No, my lord.
You have come before the vacation wage, okay, we know. I am asking them to treat this a garden reach such and such case, such and such, would be treated as a
case.
principal case,
I,
and no other case they will shall proceed, and state will ensure.
I'm so obliged. my lord.
State will ensure so that no further FIR is registered on the same set of allegation.
My lord,
Okay, state
May-
and state will ensure so that no further FIR is registered on the same set of action. And Mr. Sam, let them come with the CD. Let them come. You
them
move
come, my
it.
lord, no problem. Only one
Or
thing.
move it in fifth.
Only one thing, my lords. I'm for it.
If they
I'm
don't
sorry.
issue any notice
have-
under 35B,
My lord,
and yet arrest you in connection with garden deed, the appropriate order shall be passed.
On the next day.
my lords, it will take less time if my lords will give me 2-3 minutes.
Yes, 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 yes,
Now, my lords and my friends will bear with me.
yes.
One thing
I'm always behind.
I'm saying, I'm asking, my prayer today is, in view of whatever the law has been laid down by Supreme Court of India, not by us, my lords, and we are bound by it, is ad interim bail can be given even if they are not there. Only if I would have come, my lords, and this view, that is the first instance. They are here only if my lords feel they have been called, because today I'm the petitioner before this court, and it is if I can make out a case without any indulgence from the other side, without any clarification from the other side, then my lords can pass any interim order that feels or that is justified in law.
Vehemently opposing this.
My
That
lord, Can they, my lords?
Okay,
I can,
okay.
Can I be allowed?
If situation so demands, even order shall be passed, but let the state come with the material.
What is seeking from the
Only
material
your
on record?
petition. Except your petition, nothing is before the court.
I'm showing, my lords.
Even what statement has been made, it is not also before the
My
court.
lords, I'm showing something. I can show 3 things, my lords. I can show 3 things.
In a vacation, my lord, not in a regular court.
My lord, I can show 3 things
We are in a vacation bench. But
sufficient
then I can show
for my
100
lord
cases.
to exercise this discretion of granting me ad interim bail forthwith. That is number 1.
Yes.
That is number 1. My lords, please see the FIR of 15th. I have said, and my lord may read it, it does not disclose any offense whatsoever, my lord. It does not say what are the contents. It only says blasphemous. Will it, my lords, make it a cognizable offense? It does not, my lord, with due respect, my lords. 2, they obtain, on the 3rd day itself, 15th it is registered, 17th they take a warrant of arrest, saying that I'm not there. They served the 35B, but I was not there. So, my lords, issue the warrant of arrest. 2 questions which will arise without any notice from anybody. 1, what did you do in that one day to arrive at such that they can't go back? And within one day, the court will grant, my lords, a warrant of arrest. 2, I am, and I'm showing it. They are part of the case. Diary, please see. I am before the police in this area. I would not know, my lords, which FIR, which police station in West Bengal have registered a case. I will go for my security to my lord, police station. I went to cyber police station. I went to my police station where my jurisdiction is.
Father of the girl.
Yes, my lords. Girl also goes. Girl and the father both go.
Page 36.
Both going to the police station.
My lord. She
Page
signs.
36. Kindly see that.
Page 36.
Yes.
36, 36.
33.
36. 36.
Right, got it.
Yes.
Now see 35. They have started a case.
Please see.
When this case was started, 15.
Based on your application complaint.
Yes, my lords. It is my application. And I am saying, my lords, please see on the next page. And please see, my lords, if my lords will see the pages on 37 and 38. This was I was confronted with. Please see 37 and 38.
Yes, Mr. Banerjee, they are seeking interim bail. They are
No,
saying
I am opposing.
that they will cooperate with
No,
investigation.
I am opposing. I am opposing, my lord. Your lordship then hear me, this types of dramatic argument will be done. You can lordship can hear me.
Okay, maybe
So please let's see
tomorrow.
These are all dramatic
Let's see
argument.
what Supreme Court says. My lord, let's
These are
see
all
what
dramatic
says.
argument.
a loss, a
Let's see
student
what
of
Supreme-
law
My
of
lord, let's
yes.
whatever the video is. I don't know whether it is a made up
You
video.
don't
Video is there.
But your client
Would you
This
like to
judgment
hear?
I am to hear. What is the proposition?
having the
You
knowledge.
I'll
You don't
just
know.
read 2-3 paragraphs only, my lords.
tell- what is the proposition?
My lord, all I'm saying is all these writ petitions, when were brought before the court,
আমাদেরগুলো দিয়ে দাও।
my lord, they gave notice to the state on the first date itself, where state was there, they heard. In every case, in a writ petition, they said we will hear the petition, but granted ad interim bail. Supreme Court, my lord. they
Where
said.
is that law?
Then, my lord,
Upon the
Then-
facts of each fact.
why are they interrupting?
Yes, not interrupting.
You are going drama.
Lord,
What's
I'm so
going
sorry,
drama
please.
here?
I am coming here, I am trying to address, and I am facing hostility
Respect to you.
outside. I am facing hostility here as a lawyer. Imagine what the girl must be having,
Oh
what she is
God,
facing.
don't do drama.
It is hostility. Otherwise,
Can I
for
make my
offense of
submission?
3 years, is this the way it is
Okay,
supposed?
okay. Yeah, kindly, Mr. Sen, consider a group of people of our country got hurt following the such and such made comment in social media or where you have made this comment, I don't know, got hurt. And this case and this incident had given rise to 3 or 4 cases.
So will it change?
So admittedly, a section of the people of our country, their sentiment, you have heard their sentiment.
My lords, just a minute, my lords.
Look,
no.
we have
I'll answer
we have freedom of speech and expression.
Can I?
That does not mean that you will go on to hurt the sentiments
answer
of
this?
others.
Can I answer this, my lords?
Our country is a full of diversity. There are many person of many language, caste, community, are all are coexist.
My lord,
So while making such submission, we have to be cautious.
can I now respond? Can I
So
respond?
day after tomorrow, heaven will
Can I
not fall.
respond, my lords? Can I respond?
Yes, yes.
2 things, my lords. Number
Yes.
1,
Now you are saying, so far I have understand, you are saying they have not complied with the provisions of 41(1)(a).
there's no
Now,
ground of arrest given.
now 35(1). Certain conditions have been enumerated there. Okay, and they have not issued any notice. However, it has been submitted on the behalf of the state that notice was issued. They found that your house is under lock and key, and they took records of this.
My lord,
And that has to be considered by the court
I am
on the
not on
material.
that, my lords. Kindly, that was submission made to give the conspectors. I am not on that. I am on 2 grounds, my lords.
Now you are insisting the court
Right,
to
that is what-
grant interim bail.
So yes, my lords.
To grant interim bail only on reading the writ petition.
No, my lords. 2 things. 2 things.
Even it is not what actually uttered by the
My lord, that is-
student. already what actually uttered.
That's why I'm saying, grant me 2-3 minutes uninterrupted so that at least I can say what I'm saying. In between, something is answered. I'm unable to give even present my case, my lords. I want to present the case as my lords in law, not on facts. My lord, what will happen is, it will take an inquiry to go into whether they were there or not. I'm showing on the face of it that I'm there. So that is not the issue. What will they show tomorrow? Day after, what they can show? 3 things. They will try to show that these are the document police went there. Now, whether court can go into that inquiry or court cannot go into that inquiry is based on, again, those facts. 2, my lords, was I under grave threat and I was before the court is there. Please see, if I understand, my lords, their sentiments. But all these cases are about these sentiments only where the court granted bail right away. All these cases which I'm showing are all about sentiments of one section or the other.
This pair, your pair, a court is not refusing your pair. That pair will be considered on 5th. On 5th, let them come with the CD, what material court want to show, what want to show. And today you take that order that the Garden Reach case.
Can I say something, my lords? If my lords don't want to hear me, after lunch also CD can come. It is not too far. It is Garden Reach. It's just 1 hour away from the
dictate of the council.
It can be happened.
Court will run at the dictate of the council.
One day of
sorry.
Liberty of a student is concerned. Your lordship can always consider.
Do it day after tomorrow.
Develop like your lordship. I'm develop like your lordship.
Only no Supreme Court I will show, man.
So here only your matter will be taken up during
my custody is illegal and I'm before the court. Court is obliged, my lords, not to continue that custody.
Why illegal? You
please see.
You are arrested in connection with a particular case.
That is not important, my lord. Suppose I have done
that is not important.
No, yes, my lord. Please see what is the court says. Court says it is not about the case. It is about you have to give reasons for arrest. My lord's power to arrest is one thing in respect to connection. Necessity is quite another. Otherwise, Arnesh Kumar is redundant, my lord. Arnesh Kumar and the present BNSS, Arnesh Kumar earlier judgment of the Supreme Court say, if the punishment is 3 years or more but less than 7 years, you cannot go and arrest a person unless and there are.
Let us come back at night 8 o'clock.
Please read 35. Huh?
Let us come back at night 8 o'clock. Let him argue up to midnight 2 o'clock.
Misinterpretation
come back at night at 2 o'clock. We have also other jobs to do.
It does not behold.
Yes.
On that date,
yes, your lordship kindly pass the order. Another case. We have another case as well.
Read one passage of Supreme Court.
I don't know what is it. What's it?
What do you understand?
My insist.
I don't understand what sorts of advocacy.
Just one paragraph of Supreme Court. Supreme Court says that my lord can allow 2 days.
Enough.
My lord
Enough is enough. Your lordship kindly pass the order.
Let us see.
Enough is enough. Kindly pass the order.
My lord,
Supreme Court has said can bail in every case.
My lord, yes, sir. Supreme Court says if grounds of arrest, please see. Bihan Kumar. Please see. Bihan Kumar. Please see, my lord. My lord, that is a judgment. And
then we are all the matters are hearing by the coordinate bench. Bihan Kumar, ground of arrest, memo of arrest. My lord, my learned senior is arguing on that point.
Which point?
Mr. Bandyopadhyay. Then we are let the matter be tagged with that.
My lord, is it item 16?
All matters.
Let the matter be tagged with that. My learned senior friend is showing the Bihan Kumar. The Bihan Kumar will already is under consideration.
Please see what Supreme Court says. It is at
no. That is under consideration.
No,
what Bihan Kumar has said.
My lord, Bihan Kumar says, if the ground of arrest does not disclose exactly what is offense against me, why I am arrested.
You are unnecessary.
No, my lord.
Okay. I am saying.
Elaborate.
I am saying 35A or 41A1.
That is one thing.
One says one did not prevent the police authority to arrest.
That is not what Bihan Kumar says.
You are not allowed to make submission.
Kindly.
I'm sorry. I'm sorry.
Don't say that book was published only for you.
I'm sorry, my lords. I'm sorry. Please, I'm sorry. I'm sorry.
So therefore, there were certain conditions. And the police authority was required to issue a reason, give a reason. Okay, so it is not that as and when the maximum punishment is less than 7 years, their police authorities shall have no power to arrest. But police authority is to show whether any of the condition enumerated under subsection 1 or here 35A has been fulfilled or not, and he is to record a reason. Read the provision.
Yes, my lords. So
read the provision 41A. So if any of the conditions are fulfilled, even where punishment is less than 7 years, police authority can arrest.
May I please, my lord?
Read again. You are read for provision later on judgment.
I will read, my lord.
Yes.
Please read section 35, subclause 3, my lord. I can read, my lord. So
yes,
you can give the copy.
Court is not required to any book. You read.
Police officer
yes,
shall, in all cases where the arrest of a person is not required under subsection 1, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice. Where such person at any time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such orders as may have been passed by a competent court in this behalf, arrest him for the offense mentioned in the notice. Now, my lord, this is precisely what I'm saying, and my lords got offended. The court is not on this, my lords. I am saying something else. I am saying, my lords, that there is a necessity, my lords, to give my lords, in terms of section 47.
Have you read the 35B?
No, section 36.
If the following conditions are satisfied, namely,
yes, my lords,
then the police officer shall record,
yes, my lord,
while making such arrest, and that means this condition.
But
is
none
to
of them is there.
satisfy.
No, my lord.
Yes.
To prevent.
Now court will want to see whether any. Now
none of them is there, my lords.
Whether reason was recorded or not or anything.
It is
now
not,
you are inviting the court to go into the city.
My lord, it is not about this. Please see 47.
What court want to see?
47, my lords. Please read 47.
Yes, 47.
And that is what I am saying, my lord.
Yes.
Person arrested.
Yes.
To be informed of the grounds of arrest and the right to bail. Every person, police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or other offense.
Kindly hear me for
47 was 50 of earlier.
My lord, kindly hear me for 1 minute.
I am Mr.
Just 1 minute. Just 1 minute. I am telling you, lordship, the latest law. My lord, the Supreme Court has said in a very recent judgment, judgment was delivered by Justice Padriwal, when an warrant of arrest has been issued, the question of giving any reasons for arrest is not required. I will show it on 5th.
My lord, that...
No, I am not giving
you back. Yes, I will show it on 5th. Only he knows the law. We don't know the law.
Want to show ground of arrest.
We'll give it. But the ground of arrest is there. Everything is there. Apart from that, my lord.
Is this, does this disclose particulars? And is this in terms of page 209 of that?
My lord, what is types of
advocacy?
I don't know what sorts of advocacy it is.
Compilation
he is very powerful person.
Your lordship, kindly pass the final order. Final order after considering all.
And one paragraph and that's all.
These are final. Give me file affidavit.
Read that one paragraph.
Kindly give me the chance to file affidavit.
One paragraph. And
how many allegations have been made wrong? My lord,
Which
no, my lord,
paragraph? Which
kindly
paragraph?
give me the, kindly give me the chance of
Okay, so
affidavit.
other matter is released. Other matter are released from this list. Oh.
I am only reading one paragraph, my lord. It will not.
What?
take
You go on making submission.
No,
So other matter are released, I will be relieved.
only
Ah,
one
I have to know. Ah?
209, page 209, one paragraph, my lord, and that too I will not
Why
read the
from
whole.
yes, come, I don't know.
Please read subclause B, E, and F.
Yes, yes, yes.
B. These are the conclusions of Supreme Court, my lord. The information of the ground of arrest must be provided to the arrest person in such manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which is understood. The mode and method of the communication must be such object as the constitutional safeguard is achieved. E. When E and F, my lord. When an arrested person is produced before judicial magistrate remand, it is a duty of the magistrate to ascertain whether the compliance of section 22(1) and other mandatory safeguards have been made. Now, last, when a violation of Article 22(1) is established, it is the duty of the court to forthwith order the release of the accused. That will be ground to grant bail even if statutory restrictions on the grant of bail exist. But this is even if a PMLA is there. These statutory restrictions do not affect the powers of the court to grant bail when the violation of Articles 21 and 22 of the Constitution is established. I am saying, my lords, please read that ground of arrest. It only says warrant of arrest.
That's why my lord wants to see the material and fix the
My
matter
lord,
on chapter tomorrow.
And my lord,
My lord, may I make one submission, my lord?
Yes,
May I-
yes,
my
yes.
lord, my lord, kindly see, my
my
lord.
liberty, my lord, will be important.
Yes,
That is
yes,
the
yes.
essence.
Go on.
My lord, my lord, only the petitioners will make the submission.
No, no, no.
What is the petitioner counsel will only make the, he has come from the foreign country, only he will make the submission, my lord.
Yes, yes, no, no. No. Yeah.
In exact similar circumstances,
What is
same
this?
as a student,
Oh, okay.
in a student, bails have been granted, my lords.
Yes, Article 22. You say which provision of Article 22 have been violated?
22(1), my lords.
22 of the Constitution.
Yes, sir.
So, which has been violated? Ground of arrest is
I'll
to
read,
be,
man.
and
No person.
they have stated ground of arrest.
That is what the Supreme Court says, my lord. This is not informing. Information at the grounds of arrest would show.
So whether it
Exactly.
was ground of arrest was
My lord,
properly informed
in this
or
case,
not, that is
in
another.
this case, it was even more than this. The court said,
Unnecessary waste of time.
I don't want to. That is why I don't want
Okay,
to.
okay. Or which provision of Article
Article 1, my lords. No person who is arrested shall be detained in custody without being informed. As soon as may be of the grounds of such arrest,
I have
shall be
taken
denied
it.
the right.
I have taken collected
My lord,
from him.
this is not the grounds of arrest.
That is to be considered.
That is
No,
to be
that is
considered
what
by the
exactly
court
Supreme Court
on
says.
materials.
My lord, Supreme Court in this
Okay,
case.
But in that case, your lordship direct us to file an affidavit. We will file an affidavit, let this matter be heard after discussion.
The affidavit.
My lord,
Let us-
can I only now
Let
request
us
that-
file an affidavit, my lord. Such a serious argument has been made. My lord, he has made such a serious
Yes.
argument.
Allow the
My lord,
court.
my
Now,
lord, kindly see.
Enough,
Just 1
enough time has been vacation remains.
My lord, kindly 1 minute. My lord, 1 second. My lord, he has, kindly see, he has made very serious argument. Serious allegations have been made by him. Kindly give me a chance to file an affidavit. Let the affidavit should be filed. We will disclose everything. Let the matter be heard after filing of the affidavit. Because very
My lord,
serious
no,
question,
this is
serious
not-
facts.
Oh.
My lord, he has said about serious facts. Such a serious fact.
This is a question of
serious
interim
law
bail. Your lordship
have
can
been
keep
raised.
this matter
We
after
should
blood.
get an opportunity to file an affidavit, my lord.
My lord,
We should get an opportunity to file an affidavit. Such a serious questions of law, such a serious facts have been submitted before a lordship's court. Serious allegations have been made against us only because of his just to file an affidavit.
Okay. A student of law. Is it about
19 years.
under the why is it shouting?
My lord,
Under the jail code, she'll have a protection.
Would your lordships kindly, my lord, I have not heard the order. Would your lordships kindly just tell me the order? My lord, I have not heard the order.
Okay, yeah.
Milord will hear Mr. Bandyopadhyay.
Oh, okay, Mr. Sen, you know very well, better than me, that he is now under custody of the learned CGM.
So, my lord, by law,
If you made application before the CGM,
No, my lord, I am saying something.
CGM Alipur, CGM Alipur.
When the matter is pending.
Even
The High Court has been
in the transit remand, it was said.
Oh, they have already made their application. I am told. They
Ah,
have already made their application for all those things. What my learned senior friend is saying.
okay, so you ensure so that he
Your
can
lordship
get
has
essential
said that
medicine.
itself is a
My lord,
verdict.
kindly, my
Your
lord,
lordship has said.
As jail authorities
lordship
shall also
can-
ensure so
Mr.
that essential
Bhatt will hear
medicine
Mr.
my lord,
is
would your lordship,
supplied.
my lord, would your lordship kindly see?
Okay, jail authorities shall
My
ensure.
lordship will kindly hear Mr.
Oh,
My lord, kindly, just hear me, my lord.
Yes, yes,
Kindly
yes.
hear me. Not, kindly do not pass the order on the basis of his statement. I am telling your lordship, all facilities provided under law will be provided to him. Do not pass the order because he is making an allegation.
then this is
Aja.
fake.
Since Mr. Banerjee, senior advocate appearing for the state has submitted that all the facilities available to the inmates of the custody will also be made available to the petitioner. তার আগে in
My
accordance.
lord, if they are not giving.
And all allegations made by him are
Not
denied.
my clause for last
All
6 years.
allegations are denied.
Is this human rights? I am on offered law, my lord. This is not even human rights. I am asking.
Don't say all this.
Okay, they are claiming that they are trying.
It's human rights.
Yes,
I am so astonished, my lord.
Supply,
Appalled.
but your jail authority is not
No,
allowing.
no. Jail authority has to, one has to
I'm
wear
appalled, my lord.
all the clothes which are in accordance with law sanction. She cannot bring the foreign dresses for her. No.
Okay, since Mr. Banerjee has taken.
When I am
You
saying
will not allow me to change my clothes.
don't say.
I have a
Don't
fresh
say.
piece of clothes.
Don't say all this.
Sorry.
Coming.
I will, my lord, take strict objection of
Okay,
it.
reserve your energy for another case. Okay.
This is not done, my lord.
Okay.
This is against human rights.
Recess. Enjoy the recess.
Even my lord, a terrorist would be entitled to this one.
My lord, I'm appearing. My lord, before my lord takes up the list, my lord, I'm appearing online. My lord, before my lord takes up the list, my lord, today morning I mentioned the matter. Due to some discrepancy, my lord, communication gap, my learned junior was not present handing over the order sheet that needs to be corrected. May my lord kindly takes up the order and get the necessary corrections done. Just the name of the school. My learned junior is there, my lord.
My lord,
What? Error.
My lord, in the second page, instead of Dighara High School, it will be Kushuma High School. That's all.
my lord,
বলে দিতে হবে। আচ্ছা, at the instance of the petitioner, the matter has been treated as a test list আচ্ছা, ঠিক আছে।
মনে করাবো খালি একবার
and take up for hearing.
বলেছেন আমি খালি মনে করি
Acha, learned advocate for the petitioner, such and such, Mr. Das, learned advocate for the petitioner submits that, points out that. Court proceed.
My lord, item number 36, may I seek, my lord, I'm praying, my lord.
My lord, I could not hear the order because the ordering portion was muted.
But I'm only paying for item number 36 of the appellate side list today. Well, it's a case against the demolition order issued by the municipality. Lordship, kindly take it up at 4 p.m. Lordship, kindly, because urgency is there, my lord.
So give the relief, one relief to the court. Only the matter which would be mentioned that would be taken up for it.
Lordship, this is
the other matter will not be.
4 p.m. Lordship, 36 item number.
Lordship, praying for leave one application. That is the PH department has come. Lordship, Lordship, the PH
Which two
department.
matter? Then court will relieve.
Lordship,
This is
come back at
court books. This is a book.
Lordship,
দেখেছেন ওদের দিলাম ওরা পড়ে ফেলে রেখেছে।
Lordship will be taking it up at 4, Lordship.
Lordship, praying for leave. That is the PH department has
Come
come.
at court, হ্যাঁ।
The PH department has come and enforced the petitioner's land unlawfully, Lordship. And that is, they have come now enforce the petitioner's land who are belonging to the.
Why are you in the morning? Why are you in the morning?
Lordship.
Keep. Yes,
Should I-
other side matter.
I appear for the writ petitioners.
Yes,
Not this is a writ petition not for restoration of electrical connection, not just opposite the road. Not this 6 Old Post Office Street, not houses 129 lawyers' chambers. Not they are before your lordships, not for the purpose of restoration of electricity. A very small incident of fire breakage not took place on 10th of April 2025. CSC has inspected, their licensed contractor has carried out all restoration work and renovation work. But we had installed appliances for the purpose of not fighting the fire if it so occurs in future. Please come to the date on 29th of April 2025. This restoration work was carried out by the contractor appointed by CSC, or not the licensed contractor of CSC. Let me put it in this way. But it appears that CSC had written to the fire department for the purpose of obtention of a fire safety certificate. But it's a old building which is declared as heritage class 1 building. The facade cannot be changed under the municipal laws. Whatever may occur between CSC Limited or not the fire department, not fire department under the statute has a role to advise the premises owner for the purpose of carrying out certain remedial measures. But whatever they will do, advise us, we will carry out the same. But for the purpose of restoration of electricity, it has got no connection. Number one, no relation rather, for the purpose of restoration of electricity in the premises and not obtention of fire safety certificate. Your lordship has seen that certain instances have occurred in the Bada Bajar area hotel. Electricity is restored back. Fire certificate may come back later. Not because in the meantime, if this restoration is not allowed, these fire safety measures cannot also be carried out because not the fire safety certificate department has a licensed surveyor who has to survey the entire building and he has to give his suggestions on the basis of the floor plan map. Then not we shall have to seek for advice from the fire department. Then the fire department will again inspect. They have twice inspected in the meantime. Not this has got nothing to do with restoration of electrical connection to the premises. And not please take note 2 dates, only one. Please come to page 59.
Yes.
Not CSC wrote to the officer in charge of the fire and emergency service. Your good self is aware that on 10th April 25, a fire broke out at the above premises and your office finally dodged out the said fire. Consequent to breaking out of such fire, supply was disconnected for safety reasons. So this was the decision of CSC Limited. We have now received a communication from some of the learned advocates having respective offices in the said premises, enclosing therewith necessary test forms, certifying fitness of their installations and requesting restoration of supply. We have also received similar request from Chamaria Properties Private Limited, that's the owner of the building. Copy of the said 2 letters together with the annexures thereof are forwarded with the request to kindly provide necessary clearance of your esteemed department so that we can take appropriate steps towards restoration of supply. By endorsing a copy of this communication, we are keeping the applicants informed. Kindly treat the matter as urgent and important. Not thereafter, not these test forms are there. Please take note section 35 of the Fire Services Act.
Yes.
Yes, my lord, I'm for the state, my lord.
I appear for the state. I am appearing for the state. Kindly grant me leave to appear virtually, my lord. My lord, as far as the fire department are concerned, my lord, we have indicated to my learned friends, my learned junior is there, will hand over the instructions, my lord. We have given certain, my lord, observations with regard to, my lord, compliance of certain formalities. My lord, as far as the restoration of connection is concerned, my lord, I cannot stand in the way, my lord, because this would be the actually the, my lord, the responsibility of the CSC. My lord, this part cannot be, without recording my consent, cannot be an adversarial act because several lawyers are being affected daily. My lord, as far as state is concerned, we require these compliances to be done. But my lord, in my humble submission, can direct a time frame method by which these compliances can be done, and in the interagnum, the restoration can also be proceeded in accordance with law.
Your submission, we are as officers of the court, we also render assistance for dispensation of justice.
Appearing on behalf of CSC.
I appear on behalf of CSC,
What is your instruction?
My specific instructions are not to oppose. However, my lord, we were only waiting for a NOC, my lord, from the fire department.
NOC we will issue. I understand that NOC requires, but for that the compliances are to be complied. But that may be a time-taking process. If your lordship intervenes and directs an interagnum measure by which the fire department says compliances are also being carried out in a time bound manner. Probably the impasse can be my lord, undertaken to be taken over.
Today we have.
My lord, my only humble submission would be
Give the recommendations to the learned lawyer today. We shall try to carry out as soon as possible. But in the meantime, if the restoration is not made, but there will be severe difficulty.
my lord, my only humble, my lord, your lordship is muted.
Extremely good.
Deeply obliged from so many advocates.
Yes, all the lawyers chamber again.
Well, there are chambers of at least 100 advocates.
Okay.
My lord, I am praying signed copy of the order.
Huh?
My lord, I am praying signed copy of.
I signed copy of this order. আচ্ছা আপনি লিখে দিন তো আপনি হচ্ছে where is that advocate? You
ESC.
act on the basis of server copy.
Yes.
Huh? Without insisting the production of signed copy, certified copy, anything. Huh? The CSC is communication. Huh? 42.
And only one.
What you want? Come at 4 p.m.
Only one thing. Server copy or communication note, whatever is permissible.
Server copy or signed copy?
Communication. Signed copy comes earlier, probably.
না সার্ভার হয়ে যাবে স্যার জয়সব করে দেবেন
Signed copy comes earlier.
Acts. আচ্ছা চল কেটে দিন আচ্ছা আচ্ছা লার্নেট অ্যাডভোকেট অন রেকর্ড ইজ ডাইরেক্টেড টু হ্যাঁ
But I appear for the state.
41 you allow the court to proceed if it is not at 4 p.m. There will be chaos at least. It is your own personal
My lord, that such communication may be addressed to District Engineer Central.
লাইসেন্সি অথরিটি বলেছে তো আবার কি অ্যাপ্রোপ্রিয়েট
District Engineer Central Division Office, my lord, the communication may be addressed to District Engineer Central Division, my lord.
that order will be communicated to the competent authority. You are here, you have heard the oral now you have a procedural defect. Huh? You have heard the order was passed on the basis of this act. Unless it is come in on this table, order will not be complied with. I shall see your district engineer. Ask him to come on the 23rd. Personally appear.
I will be complying with you.
Comply with the order. Court is not bound by your procedure you followed. That unless this letter or order is placed on the table of Rambabu, the order will not be communicated. Court is not bothered with the sum.
Lord, your lordship will take up the supplementary list or the daily list. 41,
41 then supplementary.
41, 42.
Then supplementary.
তারা বলতে দাও না সবাই মিলে বলো না ভাই
So I am calling 32, 36, 41.
7 and 8. 7 and 8. Next.
7 and 8.
Yes, next. 6 up to 6 it is called down.
7 and
8.
8. Okay.
তারপরে নেবে
Which matter, bro?
supplementary after this exhausted leave matter supplementary দিন না জজ সাহেব কি
So other matter are not required to taken up.
No, according to say.
Okay, so supplementary affidavit 4. Okay, one by one I am taking.
No, supplementary list supplementary list there. দাঁড়াও না ভাই 4 বলছে only 4.
Okay, 4. Item number supplementary affidavit 4. Give. Who is for the
item 1, 2, 3 and there, Lord. 1, 2, 3 are there.
Later on.
No, my lord, leave is granted. This is urgent, my lord. Urgent, my lord. Urgency. That's why leave granted. 1, 2, 3, then 4.
Okay, so I am taking up, don't you? 7 and 8 from the
Yes, one of two up
list.
to 6 today's list it is called on. It is 7 and 8 is the due. Up to 6 it was.
Okay, let us 7 and 8, one by one. 7 and 8, thereafter 32, thereafter 36, and 41, then supplementary list. Okay?
Item number 15, my lord.
What?
Supplementary.
Okay. Court will not flee away.
Supplementary list may be taken up.
Okay. Let this matter take up. Hey, আপনি দাঁড়িয়ে আছেন কেন?
আরে দিন না জয় সাহেবকে 7 আর 8
আপনাকে আমি বলেছি 7 আর 8 দেবেন, 7 আর 8 দিয়ে দিন। Please here, allow the court.
my lord.
It is my prerogative.
Yes, my
But procedure is to be followed.
number 15 of
item number.
Don't mention, no more mention. You wait. Let this matter.
Yes, 7.
7 and 8.
7.
Seven I apply for the state.
Regularization of your service
No.
on permanent basis by
Alternative prayer. Date of interview is going to be held on 7th. My lord, I have been working there last 25 years. I prayed for relaxation of the age in view of the judgment of the special bench. They have, my lord, declined that. I may be permitted to appear after condoning the age bar in view of the latest judgment of 3 judges bench that I should be permitted to appear in the interview.
Who is your other side?
I appeal for the state. I appeal for the state. I appeal for the state.
Now, your lordships kindly see.
So, court has directed to relax the upper age.
My lord, kindly takes page 11. My lord, kindly takes page 11.
Para 25 to para 27, your lordships kindly.
Kindly takes page 11, her appointment letter. This is issued by the school, not by the state government, not by DI. Not
State
by
government has nothing to do. You see, it is about the school. Para.
No, what judgment you are showing? What
This
paragraph?
is the special bench judgment, larger bench judgment.
Huh.
Para 27, if your lordships.
Yes.
In view of the above discussion, if the appointment is made without undertaking selection procedure under the rule on ad hoc or temporary basis, engaging the candidates having requisite qualifications, namely age and education at the time of appointment against a substantive post, the candidates in those cases shall be allowed to compete and participate in the selection process along with other eligible candidates at the time of regular recruitment process, condoning the age bar as they have acquired right to be considered. Now, your lordships kindly see the
Who
mind.
is going to conduct the selection process? School.
Schools. I have served the school.
When the date of
7th.
Who is not the school authority?
Malay, we have served because the school is not appearing.
No, show me the affidavit of service. Show me that they have received.
Yes. Item delivered. They will number.
My lord, I do not know whether this is with regard to a sanctioned post or not. My lord, I from
page 20, page 20, your lordships.
Okay, take instruction on 5th.
My lord.
No, instruction of the schools have given the instruction. Your lordships kindly have a look. Page 20.
Page
20.
20 school has given instruction for you.
Yes. I prayed for. The school has given the instruction, it is not possible. We hereby acknowledge the receipt of your letter dated on the above subject. The matter was discussed among the members of the managing committee. We regret to inform that in view of the notified criteria, recruitment of the assistant teacher published, the committee members could not find it possible to consider.
So, school authority rejected you.
Yeah, rejected. That's why, my lord, the court said, larger bench said, if I serve the institutions within the prescribed age limit at the time of appointment, then my lord, right to consider is there.
That is to be examined.
Yes.
How you enter into the school.
That I have annexed. That page 16. Page 16 is my appointment letter. Your lordships kindly have a look. Even it is illegal appointment. The larger bench said it's the right to be considered.
Illegal appointment cannot be regularized.
On regular, I'm not praying for
irregular appointment can be regularized.
I am not praying for regularization. This is alternative prayer. This is the alternative prayer. I am not praying for regularization. Although it is alternative prayer to allow him to appear in the regular selection process along with the condoning the age bar. This is the appointment letter in 2007. Now it is 2025. The state has
not made of the final release.
Therefore,
you take instruction, you come on 5th.
My lord, as far as state is concerned, definitely.
You
But as far as-
instruction, even from the DI concerned, you take instruction.
But DI has nothing.
আচ্ছা, order দরকার আছে, হ্যাঁ? Come on 5th, it will be placed on 5th. ঠিক আছে?
Your lordship, fifth.
Kindly pass an order.
Eight, same.
No. Eighth is another. Seventh is the date of interview. Let it be placed top of the list on 5th. Because
আচ্ছা, fairly at the top.
Yes.
5th,
Kindly
fairly.
pass an
তাহলে
order.
let it be recorded. Let it
একটু
be.
ওপরের দিকে দিয়ে দেবেন তো, ম্যাডাম।
Kindly record an order. It will kindly record an order, my lord.
Kindly record an order.
So that it will be easier for me to take.
আচ্ছা, yes, আচ্ছা, stop, আচ্ছা। আপনি করুন। Okay, petitioner is directed to make another effort, to make an effort to intimate.
Same for the state, my lord. This is not in terms of the order of this court, my lord, this transfer has been made. But
Let him conclude his submission thereafter. Well, it is fantastic technique has been developed. Upon the petitioner, I will not be permitted to open my mouth. The respondents will start his argument. No, cut short the matter. Why the petitioner was engaged? Fantastic.
We have challenged the transfer order.
I tell you, lordship, what has happened. Without opening but a brief, your lordship, kindly have a look to this. In a public interest litigations, your lordship can allow me 1 minute, your lordship will be satisfied. In a public interest litigations, a plea was taken that a schools having without teachers. Without teachers.
Yes.
So school is running without teachers. Let there be appointment of some teachers from the other schools or nearby schools for the surplus teachers. Now, my lord, I was not a party to the writ petitions. That public interest litigation disposed of, directing to take steps for accommodated any teachers nearby the schools or surplus teachers. Now, my lord, I am the mother of a 1-year child. My lord, I have been posted. I have been transferred, or in terms of the court order, although court never directed it, that I have been transferred, and the 40 kilometers away, 3 hours journey is required to attend the 40 kilometers. Anyhow, my lord, I immediately made an application before the authority that I have no objection, I can go anywhere. But there are so many vacancies nearby schools, you can do that, you can make an application. Now, my lord, what the rule says? If there is a surplus teachers, my lord, there is a system of rotationalized, it fixed by the state government. That, my lord, your lordships, kindly have a look to this, the scheme, the policy. The policy says, your lordships, kindly see, the policy says, clause 2, policy of the rationalization of the teachers. Next page, clause 2, new entrants in the schools may be ordered to serve the less teacher or adverse PTR school in a first priority. Teachers appointed in physical disability category, old teachers who is going to retire within 2 years. Female teachers having children to take care will remain in the last priority for the purpose of the reallocations. I am the mother of 1 year and 11 years. Now, other teachers are there. He has not been taken into considerations. I have been posted 40 kilometers away in violation of the rationalization policy. This is the case. Your lordship can stay for the time being. Let it be placed. Let him come with the report.
no, my lord, strongly opposite. But this is in terms of the quarter of this court.
And what is the court's order? Your lordship kindly have
that page 21, my lord. Page 20, relevant portion.
Page 20.
That way, direct the respond about 2 and 3
Oh,
respondents.
very well. I have not finished.
Finish.
Why are you so jealous?
Not jealous.
Learned, your lordship kindly see. The petitioner has highlighted a very important issue with regard to the non-filling of the vacancies in a such and such a school. It appears that initially there are 3 vacancies from the year 2019, out of which 2 vacancies have now been filled up. One post is still lying vacant. Since the necessary to have fill up strings in the schools is important for the children to have good education, the authorities should take certain expeditious steps to fill up the said post. Learned Council appearing for the respondent WBSC submits that till the government issues the vacancy as a statement, direction for filling up the various vacant posts will not be in a position to act. Furthermore, the process to be adopted by the service commission is long-term process and may take a sufficient time. However, till the entire process is completed, the post cannot be left vacant. Therefore, we direct the 2nd and 3 respondents here to immediately take steps to post a teacher in the said school as an interim measure till the recruitment process is completed. any surplus teachers in the neighboring schools, any surplus teacher in the neighboring school can be accommodated in the vacant post in this regard. An appointment order be passed by the respondent number 2, 3. The direction be complied with within a 6 weeks from the date of receipt of this copy. Any surplus teachers. There are other surplus teachers in the nearby schools. I have.
Where is your transfer order?
Yes, your lordships kindly have a look, page 19.
Page 19.
19, 19. Utilization subject. Utilization of service Subra Haldar in compliance with the order of the Honorable High Court. Order of the Honorable Division Bench such and such. Letters of the Commissioner. You are requested to the new food regarding utilization of the service of. It is not a transfer. Utilization of the service above teacher.
It is an interim measure.
Yes,
No, no.
Only for
Utilization, let him say so. That the interim measure, it will not be finalized.
That the court is
it
it is interim measure. Yes, it is very clear, my lord. This order is very clear.
Or no? Let him say.
It is very clear for interim measure.
Not a final.
No, you
And
come
if
to
your lordships kindly,
Sir,
if I am a
it's very clear, ma'am.
surplus teachers,
you come to surplus teacher. You come to page 21.
Yes, my lord.
The order passed by the Honorable Chief Justice Division Bench headed by the Honorable
yes,
Chief
yes,
Justice.
Could be complied with.
That as a interim measure till the recruitment process is completed.
Yes.
then any surplus teachers
So
in the
you
neighboring-
say that as
any,
a interim measure till recruitment process is
Madam,
completed.
that I have
any
referred to-
surplus,
I have referred to the
language
case number,
is,
my lord.
the
referred
language,
to case number.
your lordship kindly allow me,
Because you
your
see,
language, your
the
lordship
reference-
kindly have it to the language.
You know, see the reference.
Page
Order of
3,
Honorable Division
any
Bench order.
surplus teachers,
So it is an interim measure.
Certainly, my lord, this is
So it is an interim measure.
any surplus teachers. I am not a surplus.
or interim measure.
Your lordship kindly have a look to this rationalization policy.
Okay.
Order. Policy of the rationalization of the teacher.
Rationalization of the
Okay,
teacher
policy-
working in a
Recognized
Well, this is the order of 25th
As the-
April.
how you can construe that you have been declared as a surplus teacher?
Because I have been added as surplus teacher. There is no.
No, it has not been this.
No, which I make you surplus.
Utilization of the service.
Utilization of the service.
Find any justification
my
of
lord.
your apprehension.
Your
that you have
lordship
been-
kindly have a look to this order past any surplus teacher.
So it would be, I think it would be better, it would be profitable, beneficial to you if it is clarification is made that it is an interim measure.
Let him say so.
They are saying
It is
so.
not a transfer order. Your lordship says so. Let it be recorded.
Kindly consider first, my lord, the urgency.
Yes.
5th of
urgency.
April, the order has been passed.
I have
My lord,
made.
now it